Welcome to Raising the Bar with RebuttalPR, the podcast where we elevate the stories of the plaintiffs' bar and dive into the key trends shaping the civil justice system today. I'm your host, Ray DeLorenzi, and in each episode, we'll bring you insightful interviews with leading attorneys, expert perspectives on current legal events, and in-depth discussions on the issues that matter most. Now let's jump in.
You know, it is the Supreme Court. It's a very majestic place, but once you're there, you're right up close with them. You're talking to them. It's a very intimate conversation. You have to be able to press your case, and you can't be sort of cowed by the importance of their position.
Hey everyone, welcome to a new episode of Raising the Bar with RebuttalPR. I'm your host, Ray DeLorenzi, and today I'm honored to be joined by Deepak Gupta, founding partner of Gupta Wessler. Instead of me doing an intro of Deepak's bio, I'm just going to read off a few quotes here. The New York Times has called him a skilled appellate lawyer. The Washington Post has called him an all-star progressive Supreme Court litigator. The New York Law Journal, quote, a progressive legal rock star. We can go on and on here. But Deepak, thanks so much for joining the podcast today.
Thanks for having me, Ray.
So here's what makes Deepak special compared to many of the other amazing litigators that we've had on the podcast. Deepak specializes in appellate and U.S. Supreme Court work. Gupta Wessler is the only boutique law firm that works with plaintiffs when their cases get to the U.S. Supreme Court level. So we're really excited to hear his perspective today. Deepak, how do you get in this line of work? You know, especially since, maybe 150 lawyers, let's say, argue any Supreme Court term. And there's probably, over 1 million lawyers in the United States. So we're talking like 0.01% argue at the U.S. Supreme Court. Did you ever, when you became a lawyer, the Supreme Court, here I come? Well, what was that journey like for you?
No, not at all. I mean, I went to law school, like a lot of people, wanting to be a public interest lawyer. And I still think of myself first and foremost as a public interest lawyer. And I think it's just the venue that I happen to do it in increasingly is appellate courts and the Supreme Court. And, some people argue to juries, and I argue to these, for better or worse, these other kinds of juries, sometimes of 9 people. But the way I got into it is a different path from most of the people who do this. And that's part of the problem, is that there's increasing specialization in Supreme Court practice over the last few decades, and it's focused heavily on a small number of corporate law firms around buildings around me here in D.C. And that's where people learn how to do this stuff, either there or in the Solicitor General's office. I came through a different path. After clerking for a federal judge, I worked at Public Citizen, and Public Citizen is one of the few places, a nonprofit organization, that has invested in trying to level the playing field in this area. And so that's how I learned how to do it. That's when I had my first Supreme Court argument. And then I worked at the Consumer Financial Protection Bureau for Elizabeth Warren, another institution that's trying to level the playing field. And when I left the bureau, I decided to hang out a shingle and build a firm to do this kind of work, because I realized there was this, just enormous advocacy imbalance in Supreme Court and appellate stuff, and there really wasn't a firm doing this kind of thing for the plaintiffs' bar.
So let's talk about that imbalance, and I want to go through some stats here with you. Gupta Wessler in 2023 through 2025 had 7 arguments at the U.S. Supreme Court. And if I have my stats right here, you had a win rate of 71%. And only 4 other firms, all corporate firms, had, a number of arguments, really, 8 to 10 with win rates 50% or below. So you're arguing a massive number, you and your firm, and you're winning at a high rate. Why do you think that is, particularly when there is this thinking out there that the Supreme Court isn't exactly a level playing field, and the deck is stacked against individuals versus more corporate interests?
Yeah, I mean, it is. Look, there's no denying it's a conservative court. It is. A lot of people think of it as hostile territory for our issues on things like arbitration and access to the civil justice system. I think, first of all, I encourage people not to just kind of have a knee-jerk reaction that the Supreme Court is always going to be bad for us. I think it varies from issue to issue, and it's also changed over the years. And so as a firm, we try to be really, really careful about what battles we take on. So we're really, really careful when we take things to the court. And then, when the court has decided to take something and we're brought in after that, we try to take a very careful kind of defensive posture. An example of that is two of those wins you mentioned from this past term, in a securities case called NVIDIA and in the LabCorp case, which I think anyone who practices class actions probably knows about, is about injury in class actions. The way we won those cases is not because we convinced the court to write some, magnificent opinion that says how great plaintiffs in class actions are. It's because we convinced the court that they couldn't decide the case and they had to throw out the cert petitions that were granted. So that's an example of the kind of, case-specific kind of defensive posture that we're sometimes taking in a court that people regard, I think often rightly so, as kind of hostile to plaintiffs.
So there's this mysticism around the U.S. Supreme Court that the two other branches of government I don't think have. And, our team, in advance, this was like spitballing. There's been so many TV shows about like the White House and about Congress, and there's never been a U.S. Supreme Court television show, which I feel like we were saying like Shonda Rhimes would be perfect to put something together. But why do you think that is? And what do you think are misconceptions about the court that exist because of that mysticism, or, it's not even secrecy, but there is a bit of secrecy around it too in some ways?
Yeah, there is secrecy, right? I mean, the deliberations of the court are under a cloak of secrecy. I mean, we had a couple of leaks in recent years, but that's very, very unusual. And it is, the whole setup of the court. You walk into that room. For those who haven't been there, it's these big red curtains. It's very majestic. They're wearing black robes. I mean, it's like a temple, and I think that's part of the majesty and grandeur of the law that the court has tried to kind of cultivate, and so it's an institution that I think historically people have a lot of respect for, but they don't understand its inner workings. Now, some of that's changed. If you look at the public opinion polling on the court, particularly in recent years, there's been an erosion of public trust in the court. But that discourse is generally about the really big kind of hot button political cases that dominate the headlines. What we think of in our firm is like there's also a docket that we like to call the law docket, where the court is not as much a political institution. It's behaving more like a court of law, and it's deciding questions, and we think we can win those cases if we bring the right legal arguments to bear. And sometimes that means using conservative methodology. It means, like in this recent class action case, we traced the history of things that look like class actions all the way back to English law. And those are the kinds of arguments that can resonate with these justices. So I think if you look past the kind of headlines about the really big hot button cases, it is actually a court.
Take me back to your first argument at the U.S. Supreme Court. I want to know a little bit about the case, but also what was your preparation like, and like walk me through how you were feeling in that moment. Because you could be like, oh, it was just another argument, but like we know it wasn't.
No, it's never just another argument. And no matter how many times I go there, I'm always going to feel some nerves that morning. And honestly, if that ever stops, I should just pack it in, because I think it's helpful. So I'm an obsessive preparer, and we do lots and lots of moot courts in our firm. We do that not just for the Supreme Court, for everything, but particularly for Supreme Court arguments. When you get up there, by the time you get up there, those questions shouldn't be questions you didn't anticipate. They should be questions you've thought about a lot. So for my first argument, and for every argument since, I do tons of moots. I want to have the hardest questions and really think them through way in advance. The first case I argued, and I don't recommend this, is arguing a really big case as your first one, but it was AT&T versus Concepcion, which the court decided 5-4 on class action bans. And despite all my preparation, I remember being in the Supreme Court cafeteria that morning, and I looked down at my hand, and it was like shaking, which was like objective proof, if I needed it, that I was in fact nervous. But I'm sure lots of advocates have this experience. Once you get up there and once you start talking, you forget all of that. You're in the moment, and you've spent a lot of time thinking about how you're going to react, and it's almost like you've developed a muscle memory. When you hear that question, you already know what that question is, and you already have started to think about how you're going to formulate your answer, and then you can actually listen carefully. You can be there in real time. And the more I do it, the more comfortable it gets, the more I'm able to kind of be there in the moment, listen to what's really happening, pay attention, because I'm confident that I've done whatever I can to prepare. At a certain point, you get to a point where it's like, okay, I've done everything. Now I just have to do this.
So how many have you argued at the U.S. Supreme Court now?
So I think the one I just did was my 8th.
Okay.
Argument for it. And for us as a firm, I think we've had like over 20.
So the firm said over 20, and the question I'm getting to is, it's like Tony, the environment in the court, and that the justices, there's repeat players, like you and folks at your firm. There are folks at more corporate firms that have done more than one argument. Talking 5, 10, dozens potentially, and it's just, I find it interesting compared to what you see at like a trial level and a run-of-the-mill argument. There is not a combativeness that you see in the lower courts. And, in fact, there was a big story in this last Supreme Court term. I'm not going to say who the Supreme Court litigator was, but they got smacked down by one of the justices. And this person had appeared many, many times and said something pretty dismissive of opposing counsel. And I'm curious that environment, how do you, it's like your adversaries, but you can't be adversarial in some ways or combative. And
that's right.
Walk me through that a bit more.
Yeah, I mean, I think that I think this is just true of appellate and Supreme Court litigation in general. One of the things I like about it is that you can be collegial. It's easy to be collegial because you're not fighting over stuff like discovery. The only thing maybe you're going to disagree about is like whether to take an extension. And so it makes it easy in a collegial environment like that, where you're not fighting with each other, to be friendly with the people on the other side. And because there's so few people doing it, you might find yourself opposing each other one day and being on the same side another day. And so it's important to, I think, cultivate those friendships. And the stakes are high, people are competitive, but the justices don't want to see people personalizing their combat in the Supreme Court. I'll mention the advocate that you mentioned. It's Lisa Blatt. She's a friend of mine. She has a unique style in which she is a little bit more, a lot more combative. And I do think that advocacy at that level brings out people's unique styles and approaches, and you kind of have to be who you really are. I am just by nature never going to be that combative, and I think it serves me well in situations where somebody like Justice Alito, who might not agree with everything I'm saying, if he was going to raise the temperature, I actually, by not being combative, kind of lower the temperature. And there's a recent argument where he and I were actually agreeing quite a bit. So I like that about it. I think some people are better suited to the rough and tumble of a trial litigation and discovery fights and things like that, and other people are more well suited to that kind of discussion. It's a little bit more, like a philosophical debate than it is like a street fight.
Because there's so few of you that handle these arguments on a regular basis, I understand that you get to know the justices. You don't know them personally, but you get to know them to a certain extent. When you go or your colleagues go in to argue, do you fear or wonder, like, are some of the justices being like, oh, here comes the plaintiff folks again, versus they may not have that view of someone who could be on any side of a commercial dispute? How do you sort of deflate that balloon, or do you think they don't even think of it that way?
I mean, I do think, just like in any court where you have people that are repeat players, if there's a local traffic court and there's somebody who's there often, judges are going to form opinions of those advocates based on their advocacy. So if there's somebody who's credible and trustworthy, the judge is going to trust that person, right? And if there's somebody who shades the truth a lot, they're going to be concerned about the representations that they make. So I think that's true in the Supreme Court, just as it would be true in any court. But I don't think that the justices are like, okay, well, you represent these kind of clients, and so I have a natural inclination against you. I think to the contrary, the justices, they, what they care about is the legal arguments and the jurisprudence that they're going to set for the whole country. I do think there was like a moment in my career where I really started to feel comfortable, and that was I had this case where the Supreme Court invited me to argue a case. This sometimes happens when there's not one side that continues to press its position. So the Solicitor General had abandoned a position, and the court asked me to argue. And so I was actually arguing a position I normally wouldn't agree with. I had to argue an anti-plaintiff position in that case. It was the only time I've done that. But it made me feel very comfortable, and the justices, I think, they value the service that you're providing to the court. And ever since then, I've kind of felt like, it is the Supreme Court. It's a very majestic place. But once you're there, you're right up close with them. You're talking to them. It's a very intimate conversation. And you have to be able to press your case, and you can't be sort of cowed by the importance of their position,
Okay. So when you're approached about taking a case on, this is it's like a vote counting exercise. Like in some ways, you need to get to 5. But
That's
also,
right.
when you've talked about some other cases, like what if we get to a place where it's just 5 say this shouldn't have been granted in the first place? Like, how do we even walk me through sort of how you get your arms around an issue that, it's something that's been going through the lower courts. You may have had no familiarity with it until a lawyer comes to you and says, hey,
Yep.
the other side is seeking cert. What do we do?
Yeah, I mean, I think that, one of my favorite things about this kind of practice is that moment when you come into something and what you're contributing is your fresh perspective. So, somebody has been battling something maybe for the better part of a decade, and you can lose any kind of perspective by doing that, right? All the facts, you were there. What you don't have a sense of is how is this going to look on a cold, hard record when it goes up to an appellate court or to the Supreme Court. And so that's a big part of what we provide is just, perspective. And then also we're narrowing the way we're looking at your case to the particular issue in question. So, any advocate, a plaintiff-side advocate, is naturally going to think about the case as a whole, whereas appellate courts and the U.S. Supreme Court are going to think about, whatever this particular jurisdictional point or the particular legal question. And so, I think the more, every year that I do this, I think I get better at being able to see the big picture and focus in on the thing that's really going to resonate with the judges or the justices. But it's a collaborative exercise. Every single case that we do with co-counsel. And I think, there might be some people who do this who just think, oh, it's my way or the highway, and they just kind of take over, and whoever was working on it before, they don't really talk to them. I think that's really stupid, and that's never our approach. Our approach is always to work really closely with the trial lawyers. They're always going to know more than, we do about the record. They're going to have deep familiarity. And so what we're looking to do is create a team for each case, sort of on the fly, that brings out the best in everyone, where you're getting, you're harnessing that experience, but you're also harnessing our ability to know and to predict what the appellate judges or the justices are going to see in the case. And you mentioned, what do you do when somebody, the other side's petitioning the Supreme Court? That's actually my favorite moment, because there's so much bang for the buck when we can come in and try to keep the case out of the Supreme Court. And that's never about like who's actually right or wrong on the legal issue, right? It's about the dark arts of what motivates the justices. And so that's actually like my favorite kind of brief to write, is just like, there's nothing to see here, move on, and you preserve plaintiff-side victories, and you kick the can down the road. It's not as glamorous, it's kind of under the radar, but I think we add a lot of value when we do that.
So that's a good pivot to, while we've been talking about the U.S. Supreme Court, you do a ton of writing and arguing at lower appeals courts, at the state and the federal level. Let's talk about some of the state appellate work you've done. You had a huge win in Nevada recently regarding a case involving Uber. You've done work regarding PCBs. How does the approach differ, particularly when you're like getting dropped into a state where, like, 9 Supreme Court justices, but let's say you're, the Nevada. I always say Nevada. I never know which one's correct, but
Nevada,
in any event,
it's very important not to get that wrong when you're there.
But you don't know those justices as well, I assume. But so how does that, affect and impact how you approach those cases?
Well, I think it's a really great question, and you have to approach it with humility. Actually, I do know the Nevada court kind of well now, because I've just been there twice in the past year, and I just came back from Nevada, where I spent some time with most of the justices at the Nevada Justice Association convention. But I think it is tough, because there are 50 states, and they each have a unique legal culture and politics, and those people are separate, totally distinct individuals. And so if I'm coming into a state for the first time, like I said, I have to approach that with a lot of humility. First of all, I might just talk somebody out of hiring us. I might say, what, for this issue, it's really very state focused. We might not add some value. You probably don't need us. But, if it's a high stakes matter, and we think we can really add value, then what I do is I try to talk to a lot of people in the state. I find, maybe a recent solicitor general. I talk to people who have clerked on that court. I bring those people into our moots and strategy sessions, and really try to understand how that court thinks. And in state Supreme Courts, you can actually ask people that are recent justices on the court, which you can't do in federal court because they have lifetime tenure. But we do that, so we include those people in focus grouping and appeal, and we really spend a lot of time so that by the time we're up there, I like to feel I know that court as well as anyone who's living and breathing it in the state. But it takes work, and that's a big part of our process. We do that for anything we're arguing in any court. We really have to put work into making sure that we know better than the other side does how the court is going to approach that case.
Some trial lawyers, unsurprisingly, may have a bit of an ego, and they say, and look, there's a lot of incredible trial lawyers out there, and they can go in front of a jury and make that argument. But then they carry it forward, being like, if I can win over a jury, I can go handle the appeal too. Yeah. And I'm curious about, and I know this is sort of a self-serving question in some ways, but for how you convince a lawyer who may be on the fence that, you should bring in an expert on this, and you may not be best served by making the argument. And I know these things are often on big issues. There's a lot of people in that lawyer's ear, but I'm curious as to, how you navigate that.
Yeah, I would say I don't really try to make a hard sell about this. I think, look, there are a lot of really fantastic trial lawyers in this country, and some of them also do appeals. And, if it's an appeal that's really fact-bound and they know the record really well and there's not that much at stake, it might be a totally rational thing for them to keep it for themselves and do that appeal. I don't want to suggest that, this is some domain where only people like me can do it. But I think that I think there's an increasing recognition because of the corporate side appellate specialization, because people see how much value it adds for the defense side. They recognize increasingly that we need the same kind of specialization on our side. And so, like I said, I don't try to browbeat people into bringing us on board. I think, if people recognize it's a situation where the stakes are high, the legal issues are novel, they're going to come to us, and we're happy to have conversations with them about how we work with people collaboratively. I don't think it really pays for people who do this our kind of work to have kind of an arrogant, elitist kind of attitude. And it's just not our style anyway.
So how do you approach a client? Let's take, LabCorp, where, it was granted and, there was concern about what could happen here. And you're like, the strategy is essentially, to, sort of cut our losses, or, in a very good scenario. I mean, of course you want to win, but you also know the circumstances around the case and you have to strategize. But it was a massive win to have essentially the court, say that, we shouldn't have taken cert on this in the first place. What's that conversation like with your client to be like, this is how we're going to do it, when it seems it's like we're not going for a straight, win on the issue when they've been invested in the case for so long?
Yeah, no, it's a really good question, Ray. And I think, the answer is going to differ from case to case. But in that case, LabCorp, for those who don't know, the issue was, is it okay for a court to certify a class action if some of the people in the class could be uninjured? And there was a constitutional dimension to that argument and a Rule 23 dimension. So I would say it's safe to say that the entire class action bar was freaked out when the court granted that case, and not without good reason. And I wasn't involved in the case until actually I think the first conversation I had with the plaintiffs' counsel was the day that the Supreme Court granted the case. And so, that's something where that grant, this is an issue that's been floating around for a long time. When the court grants that, there's a very, very serious risk of a negative decision. And I think, you have to go into that in a somewhat defensive crouch. And I think you have to level with the people you're working with and say, look, if you think we're going to get some, victory where all the justices are going to say how great class actions are, and, that's just not realistic. And so we have to temper our expectations. And, at the time that the court had granted the case, I don't think it was apparent to me that we had this path where we were going to be able to tell the Supreme Court, as we did at argument, hey, this cert petition is fatally defective, and you have to dismiss it for lack of jurisdiction. Often, it's just not apparent that those arguments exist until you really, really dig in. And so, what I hope we do is we build trust with the people we're working with. We have experience in doing this, and that we're going to be able to dig in and find the best arguments to try to land that plane the best way we can. And sometimes it's a damage control exercise, right? Sometimes it's like, look, there's no way to really, really win this, but what's the way to lose this in the least bad way?
I want to talk about mentorship. And while we've been talking about you and all the Supreme Court and appellate arguments you do, you have amazing colleagues. Matt Wessler founded the firm with you. He's argued several times. You have other folks you work with who have had their share of U.S. Supreme Court and appellate arguments.
Yeah.
How do you get folks sort of ready for that? What's your approach? And also, I'm curious, do your clients say they're going to be the one to be the first, like my case, like they're going to this is going to be their first argument? And how do you get over that, with them?
Yeah, it's a great set of questions. And I have to say, this kind of stuff is one of my favorite parts about having a firm. There are a lot of these Supreme Court and appellate practices they're based around one star who kind of takes all the arguments and does everything themselves. And I've never believed in that kind of system. I've always wanted to have a really team-oriented approach. So every single one of our partners has argued before the Supreme Court. All of our associates get arguments. We try to get them in court all the time. And we have a summer program where we get amazing summer students. We have a fellowship program to try to bring people into our kind of work right after they've clerked. And all of that mentorship and training is like a huge part of what we do. Because think about it, there are all these, corporate side appellate groups, but there aren't people doing what we're doing. So we need to build a site of training so that we have talented lawyers who can do this kind of work. And it's my totally firm belief that this kind of work does not work if someone's doing it alone. It has to be a product of collective brainstorming and teamwork. And, if I'm doing a moot, it can't be a situation where someone's afraid to say, hey, you know what you said? That makes no sense. That's stupid. That's not going to work. We have to build a culture where people feel comfortable, and it can be a really vulnerable moment when you're getting ready for an argument. It's very emotional, actually, that process, and so it's very important to have team members that feel comfortable with each other, getting people to that moment where they can stand up at the podium and be the best version of themselves and do the best job for our clients. So the moment where one of our associates is arguing an appeal for the first time, that's one of my favorite moments for us as a firm. And really when they're there, the whole firm is there in some ways at the podium with them. We are all watching it if it's video broadcast and commenting on it together and sharing in everybody's success. So it's a wonderful part of our firm. And we have people that are alums of ours that have gone on to, we have one alum of our firm who's now a federal appellate judge. We have an alum of our firm who was the chair of the Federal Trade Commission. We have somebody who's running appeals for all of California at the ACLU. I'm really proud of all of our alums. And I think part of what we're trying to do is brainwash the next generation of people to realize, hey, you don't have to, if you want to do this kind of work, you don't have to do it for corporations. There is a path where you can do it in the public interest.
I've gotten the sense at the U.S. Supreme Court, when someone's arguing for the first time and really has no business arguing, they don't have the patience for it in some ways. But it's the opposite when someone, let's say from your firm, is there for the first time. They almost are excited for them in a way, yeah. And they offer, I don't know if more patience, but they're not there to beat them down. And I'm just curious if you've gotten any sense if the Supreme Court in particular really values your approach and having more people argue from the firm, knowing what your perspective is versus seeing the same people up there time and again.
Yeah, I mean, I think justices they're going to be careful about what they tell you directly about this, but I do think, they certainly know us. We're there often. I got that appointment, which was really nice. We send clerks there. They hire our alums as clerks. And they're just moments like my colleague Jennifer Bennett, who has mastered the history of the Federal Arbitration Act. And I can think of a moment where Neil Gorsuch was talking to her and Justice Gorsuch said, I'm sure you know the answer to this. How does this work? And you can just tell that there's a kind of trust that's being built. I think that's a strength of our approach. And it also means we're better at helping each other out. If you have only one person that knows how to do it, you're not as good as helping each other out as a team.
To end this, while I think people in this country are down on all institutions, the Supreme Court, though, has taken its fair share of lumps over the last couple of years. Give people some hope out there, especially for those on the plaintiff side when they are, have an issue of importance and they're at the U.S. Supreme Court.
Yeah, well, let's bracket out the future of American democracy and our constitutional order. If you're just thinking about how do plaintiffs fare in the Supreme Court, I actually think I am really optimistic about this because I think there was a moment 10 years ago where the court was more dominated by kind of Chamber of Commerce thinking. And I think that's really changed. I think some of the newer justices, they care about access to justice. They care about some of the modes of argumentation, like historical arguments. They care about that stuff, and you can reach them, and you can win. I think our record over the past couple of terms is proof of that. And I think ultimately you have no choice but to be optimistic. It's the only court we have. We've got to work with what we have, and at least our example is proof that that we can prevail. And so I don't think I am not cynical about our prospects. I know that a lot of people are, but I think if you really look past the headlines and look past the political battles and the culture wars, there's work to be done, and the law actually matters.
With that, Deepak Gupta of Gupta Wessler, thanks so much for joining the podcast.
Thanks so much for having me.
Thanks for listening to this episode of Raising the Bar with Rebuttal PR. Don't forget to subscribe and follow to join us next time. See you then.